Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. The topic today is divorce and family law with some case scenarios and some questions from our viewers. Joining me once again is a co-host, Jesse Barrantes. Jesse, how you doing?
Good, Dave. How about yourself?
I'm doing well. Good to see you today.
Great. You as well.
Well, we've got a big load here of cases, questions, and I want your expertise on this. It's very important stuff.
Okay.
We're going to start with Kevin and Steger. A little background on Kevin. He's got 2 kids, a 6-year-old boy who's into baseball, and he's got a 9-year-old daughter who's into art and drawing. He works as a medical tech. He earns approximately $60,000 per year. His wife is educated, but she refuses to work. She may be bipolar, anorexic, and psychotic. What a combination.
We can say that about a lot of people, Dave, can't we?
Yeah, but here's the catch. She refuses to seek any treatment whatsoever. So the question that Kevin has from Steger is he's considering fighting for custody of these 2 children, and he wants to know what the best interest of the child standard is and what his odds are.
Well, since you said they had the oldest child was what, 9?
9 and 6.
9 and 6, and so I'm making an assumption that they've been married for at least 9 years, maybe longer than that. I'm guessing that if his wife has those issues or conditions, that she's probably not working. I don't
She's
know
not
if it
working.
says,
She refuses to work. She's a stay-at-home mom.
Right,
She's
right.
educated, but she just says, hey, I've got the 2 kids. I'm raising them. You're making your 60. I'm not working. Because the agreement was once the kids were of a certain age, she would work either part-time or go back full-time, you know, to supplement
Sure.
the family income, but she just refuses.
But who really wants to work though, Dave? Right? I mean, you know, even a rock star, right? You might think it's a pretty good idea, but it's still a job any way you look at it. But here's the deal. You know, what's really important, it doesn't matter necessarily that somebody has those conditions. Okay, what matters is what's happened to the children. Has she done anything that would indicate that the children you know, either might be in danger or maybe it wouldn't be a good idea for the children to be there? Because what I'm hearing so far is for at least the last 9 years, 6 to 9 years or whatever, she's been a stay-at-home mom and she's taken care of the children, and he's worked.
Right.
Okay, so there's nothing, you know, somebody went off their, I mean, it's a serious condition and something definitely to look at. If somebody, for example, is on medication that might be mind altering, you know, that's certainly an issue to look at, because, you know, that might prevent somebody from being able to properly supervise the children. But, you know, it's going to be difficult to say, hey, listen, right now, you know, for the past this time, this is the situation, and now all of a sudden it's not acceptable anymore because I want custody.
Right.
However, the standard for the best interest is you know, again, it's just best interest. And what's going to happen is a couple things. Once he goes into court and files a petition for custody, they'll be sent to mediation, and I'm certainly a mediator in DuPage, and you know, mediation program is really good. Sometimes issues of custody and visitation or parenting time can be resolved seriously when you have the mediation. Sometimes they can't, but a lot of times they can. That's the first step. Then the next one is either a guardian ad litem, which I'm a guardian ad litem too in DuPage, would get appointed, and that person does an investigation and reports back to the court orally and or in writing, depending upon what the order says, on what the investigation revealed and that person believes is in the best interest of the children. Or they can, either party can petition the court for a 604B custody evaluation. That'll probably set somebody back, I don't know, maybe $6,000 to $10,000, depending upon what it is. That person is a psychologist and will talk to everybody, will run psychological tests. And in a situation or a case like this where somebody has bipolar and other kinds of issues, or sometimes it might be that one of the parents are alienating the child from the other parent, which means basically trying to brainwash the child, telling him that the other spouse or other parent is no good and doesn't care about him, and those kind of things. And a psychologist is really trained to be able to do that. And then they will make a determination. So if he, you know, your children are worth fighting for, but realistically, you have to sit back and think, is that going to do them more harm than good?
Well, he has stated that in the most recent couple years, the children, as they have aged, are starting to show some signs or effects of this kind of abusive situation between the mother and the children.
But when you say what kind of abusive situation, because just simply having a
Well, the
bipolar
bipolar,
disorder-
the ups, the downs, the screaming, the yelling, and then the kindness, this juxtaposition is definitely got the children walking on eggshells, let's say.
Well, and certainly that is something that needs to be looked at. But again,
Only from mom.
Only
Dad,
from mom,
it's
right.
stable, everything's cool. But with mom, it's hit and miss.
sure. So I think they most likely would benefit probably from a 604B, and it really depends upon where you're at.
If he pulls the trigger on a filing, it's going to be a drastic change in lifestyle.
Well, I tell you, I mean, if he's that concerned right now, probably one of the short-term things that they can do would be to go to counseling, even together as a family. I mean, I don't know if the marriage is dead marriage, or if whether or not that's something that they can go to seek contrition.
It's a dead marriage if she will not seek treatment for the bipolar and the psychotic nature that she's getting involved in. So it's up to, if she wants to seek some treatment, it may be salvageable, but otherwise he has to make a decision, and that's what he wants to know, what that best interest is.
Well, I really hope everything works out for him.
Okay, let's move on to Karen, another scenario. Karen's involved in a 16-year marriage, 3 children, ages 14, 12, and 8. 2 boys, 1 girl. The kids attend a private school, and they're very involved in church. No one can believe that these parents are going through this type of situation because they put on a front for everybody that everything is fine and dandy when they're really going through a matrimonial crisis. Finances are at issue here, Jesse. The husband earns a modest income, yet he attempts to provide the best things in life for his family. The wife chides him to earn more. And Karen wants to know,
The wife?
guardian, yeah,
The wife wants to know. Okay.
the wife wants him to earn more.
Right.
She wants to know what the point is with a guardian ad litem. Why does she need this, and why does she have to pay for it? Because they're going through this divorce process, and the court has ordered this.
Well, if the court has ordered it, I mean, generally a guardian ad litem is appointed if there are, the court's worried about the children, there's specific issues, especially immediate issues, or if there's issues with parenting time or custody. So, again, as I said for our last caller, that the guardian ad litem is an attorney who has received training and who gets appointed by the court, goes out, does an investigation, interviews people, usually talks to the parties individually, with the kids, talks to the kids alone, different times, and maybe other people that the parties might think are relevant, looks and obtains records if there are any medical records, or talks to the children's counselors if they have counselors, or talks to the teachers to see how they're doing in school and all those other things. And then there's other kinds of, the point is doing a well-rounded investigation, and then to make that recommendation to the court on what he or she, the GAL, believes is in the best interest. The reason why they have to pay for it is because it's court-ordered. I mean...
Yeah, but here's the deal. I told you finances were at issue. We're talking about 3 children.
Right.
He earns a modest living. They're trying to send the children to, or they are
Does she
sending them to
work?
private school. She does not work.
Okay.
I mean, she's got her hands full,
Sure.
with a 14, a 12-year-old, and an
Yeah,
8-year-old.
but it seems to me that there's no reason why she couldn't work if she doesn't have any other skills. The children are old enough to be going to school, and if they're in school, there's no babysitter, and during that time in school, certainly it seems to me that in order to supplement the house, the estate, because we look at the marriage as just like a single estate here, everybody has to help out, Dave. Like I said before, not everybody, I mean, who really does want to work? Some people enjoy what they do, which is great, and that's a fantastic thing. But look, we're dealing in realistic economic times, and everybody has to contribute. Everybody has to work. It's it's everybody taking care. It's not just dad taking care of the children. It's mom too. And if she has an opportunity to be able to help to do that, she should. They're both really charged to be able to take care of the children. And if they're going to get divorced, guess what? I know could pretty much tell you what the judge is going to tell her.
Yeah. Well, I think if she was here, she would tell you that being a mother of 3 is a full-time job,
Well,
and give it a try sometime.
It definitely is. Okay. it certainly is a full-time job, but there are certain realities, and that's one of them.
There's just not enough money for the private school, the guardian
Well,
ad litem, the child support. Something's got to give.
Something's got to give. You can't live beyond your means, although everybody does it most of the time. That's why we have bankruptcy, and I think probably that's going to be the topic of our next show. But
Right.
realistically, hey, listen, I mean, you could certainly have a champagne taste, but you can't have that on a beer budget. I mean, that's just the way that goes.
Could she advise the court that she cannot afford it and there
She
shouldn't
can.
be a guardian ad litem appointed?
Well, or sometimes the court will appoint a guardian ad litem pro bono, which means at no cost. And so they have also legal aid attorneys and guardian ad litems that they appoint, which they could, depending upon the specifics of their economic situation. But again, that's up to the particular judge and the parties. Obviously, if they can pay their attorneys, the judge is going to look and say, well, there's something, not kosher here.
Okay. Moving on to Lindsay, and Lindsay is a gentleman from Blue Island. A little background here. This gentleman travels for a living. He's only around town 2 days per week. So he's gone most of the week. He's back in for 2 days. The parties officially separated 9 months ago.
Okay.
So this has been a fairly long separation period here. Not much communication since then, as you can imagine. I don't know how much communication there was before. He was gone most of the week. Support is at the rate it's coming in at $1,400 per month. He's paying child support to the mother, and the wife controls everything. The husband has zero say in anything affecting the child. So he's working his butt off. He's paying big support, but he has no say. And Lindsay wants to know, and again, he's from Blue Island, Illinois. He wants joint custody of his son. Why is this so hard to accomplish, he wants to know. He just wants to have a say in his son's life.
Well, I tell you, a lot of people, they need to know what the difference is, and we want to make sure, because people focus on labels a little bit too much. The difference between joint custody and sole custody is in a joint custody situation, the non-residential parent, the person who doesn't have physical possession of the minor children most of the time, has a say-so in the upbringing of the child as it relates to religion, as it relates to education, and as it relates to medical decisions, but not medical decisions of an emergency nature, more like orthodontia, elective types of procedures, those kind of things. Although, you could have a say-so if you have a child and God forbid something should happen and you need to have a specialist, I think in that situation, right then, both parents that have joint custody would be able to get together to do the research on a specific expert that they want to go to, and the pros, and they should do that, because again, they need to set their differences aside for the sake of the child, and so that's why those things are important. But a sole custody is exactly the opposite, that the non-custodial parent doesn't have a say-so, and the custodial parent gets to do those things unilaterally. It doesn't mean that you lose your rights as a father or mother if the other person is awarded sole custody. It just means those three decisions. Generally, as the children get older, and you said the children in this case were...
It's one child.
How old is the child?
11.
11 years old. At this point, probably religion's already established. Probably they're already in school, public or private or otherwise, so that's not an issue. And then the other thing is probably the medical stuff. So he didn't say anything about it, so I'm guessing, hey,
Well,
I think that if they were going to have braces, he would already had them
Right.
by
Well, here's
now.
the situation.
Yeah.
Nothing has been filed in court yet.
Right.
They're separated for 9 months,
Well, he's doing the right thing. He's paying.
but child support is in place.
Well, is
Separate
he
order.
Is he paying? Okay, so she filed a support order.
She did.
Okay, so he's paying. Then I'm
She's
guessing the
got
appropriate
the
amount.
perfect situation right now. She's got the child. She's receiving $1,400 in child support per month. The father is hardly in the life,
Right.
and she's making sure that he's not in the life for the couple days he's back per week.
Right.
So she doesn't even need to file for divorce. She's got
Well,
what she wants for the most part here.
I don't know if that's that might be the perfect situation for her, but I can tell you it's not the perfect situation for the kids or for him.
So he needs to file something.
Definitely, if they went in, because a lot of times, people can go in and the state can file a petition for support, or you can just file a petition for support to get the money going. But he needs to go in. I mean, if the marriage is dead, if I'm I always advocate, I always ask people when they come in whether or not they've tried counseling, whether or not there's a possibility that they can reconcile. And if they can't, I get it and I understand it. But if there's a possibility, or if somebody answers a little too slowly, then they should probably try. And if that doesn't work, definitely, in this case, he should more than likely get the divorce, because then
Right.
I'm guessing, because you didn't say anything, he hasn't complained about child support, that's probably represents 20%
Yeah,
of
the
his net
child
income.
support is the state guideline,
Right.
so he's fine
So,
with that.
and that's what he's going to be paying anyway, in addition to some other stuff. But we're looking, it's the same situation there too. We're looking at a marriage now. If he does do the divorce, he might be on the hook for some maintenance. Probably going to be temporary maintenance, where he's going to pay till she gets an opportunity to be able to get a skill if she doesn't already. I didn't hear anything about that. There's a lot of things that how that can be calculated in order to.
The mom's focus is the child.
Right.
She has the child. She's getting support for the child. So she's not looking to dissolve the marriage and
Well,
obtain
but he
the
should.
50% interest.
But he should, and more importantly, he needs to file a petition for visitation, and that can only be done if you take care of the petition for dissolution. Because-
Realistically, though, what kind of visitation can he get? He's only in town 2 days a week.
well, then he gets 2 days of visitation.
Yeah, I don't think he wants that.
Well,
He wants every other weekend, maybe a day.
Well, but if you're saying he's only in town, then there's different ways to do it. If it sounds like he might be a truck driver. That's kind of what it sounds like to me.
Yes.
So they're away. But if what good is it if you're ordered to have every other weekend and you can't exercise it? That's not doing anybody any good, unless you can adjust your schedule to be able to make that happen. And it doesn't have to be every other weekend. It could be different. Talking about joint custody. Joint custody is only for people who are able to agree on issues as it relates to the children. But if they can't agree on it, then they're not a candidate for joint custody, and the court really can't order the joint custody. And what's going to happen mostly is either they're going to award sole custody to one person or the other.
Okay. Moving on, this is the case of Terry. The situation here, Jesse, we have a divorce that took place 4 years ago, so we're post-decree.
Okay?
The child is now 10, and the judgment calls for alternating weekend visitation. It has not been consistent. The husband has struggled, unfortunately, with alcohol. The ex-wife then refuses the visitation because he's not in his right frame of mind. Husband accepts his weakness. He's taken corrective action. He has joined AA, and now he wants to get back to the schedule that was listed in the judgment. But the ex-wife doesn't want to comply.
Okay.
His name is Terry and Joliet. So he says, visitation under my judgment for dissolution has gotten difficult. What recourse do I have against my ex?
Well, the order is what the order is. If he's been granted every other weekend visitation, he's entitled to have it, absent those things that you're talking about. If he has his alcohol issue under control and he is sober, or certainly not intoxicated or hasn't drank before picking up the child, then he should have it.
Yeah, the ex is not convinced that the sobriety has taken place.
But
that's part of it.
It would be up to the ex to file a motion to modify visitation. But what he can do is certainly file what they call a petition for rule to show cause. Anytime there's an order, in order to enforce the order that a court has done when one party is not following it, is to file a petition for rule. It's a rule to show cause why the other party shouldn't be held in contempt of court.
He did that once before.
And what happened?
He relapsed. So when it went to a hearing, it was brought to the court's attention where he was. He was actually in a rehab facility at the time,
Right.
so he never had his day
But
in
it wouldn't
court.
be right. It wouldn't be willful. That's the thing. If somebody violates a court order, if somebody comes to pick up your child and that other spouse is intoxicated, you better not let your children get in the car with that person, okay, or go with that person. That's not willful. There's a reason
Right.
why you've disobeyed the
Well,
court
he
order.
was taking the child places and then drinking.
Right.
So they would go to like a baseball game, and
Right.
he would have several drinks.
That's still an issue, but she needs to file a motion to modify visitation. And again, that could also cover all kinds of things, like he's not supposed to drink within 24 hours, before and during visitation, certainly, or that he's required to seek treatment and then to provide evidence to the court or to the other person. But he can still, because I'm guessing it sounds like that even after that one time where he tried to do a petition for rule and he relapsed, that she's denied him even more. So each event is a separate event.
Right.
And so, and again, I don't know what happened on the other one.
Allegedly, she drinks too.
Well, but we're not talking about her now, are we? We're talking about him. That's the issue. We're not going to convolute the issues, and you can't say, oh, well, listen, no, it's about, that's what it's about. You violated the order, and there you go. Perhaps then he needs to file another motion to modify custody then. If he thinks that
he's
she's
not in a position
well,
to do that
but again, I mean
financially either.
that's what you're looking at. Or maybe the kid should go to grandma and grandpa's. I don't know. It just depends on the particular situation. But neither one should put the children in that kind of a situation.
Okay, let's move on to Laura. Laura is seeing dollar signs. She's married to a Chicago police officer who is nearing retirement.
I thought you said she's seeing dollar signs.
She is. You'll
Okay.
see.
All right.
He worked on homicide cases for 10 years. He fought against gangs and violence during the last 3 years. However, he has not yet faced an adversary quite like his wife. She wants blood because he has a girlfriend, a very young girlfriend, 28 years old. They've been together for 29 years, but they were only married for the last 6. So she wants a piece of this pension, and she wants as much as she can get, and she's upset about the girlfriend.
Well,
She wants to know
understand.
what could she be looking at and how does she obtain it.
And it's her question.
It's her question.
Okay, well,
Laura
hey,
from Chicago.
I got to tell you,
Bad situation here.
cards on the table kind of a person. I don't sugarcoat things. I tell people things the way that I see them because they need to make an informed consent kind of a decision. And again, you don't help anybody if you tell them what they want to hear, even though it's a bad situation. The fact of the matter is that they've only been married for 6 years, so it's a short marriage. Do they have any children of this marriage?
No.
Okay, didn't say any marriage. Okay, so there you go. So that takes a whole nother.
So she gets no credit under the law for the 29 years total that they were together.
No, she does not. And
That's the part she cannot accept.
Well, I see a lot of people telling me in terms of having to pay not only child support but also daycare expenses and this other stuff, and that and hey, that's the way it is. I mean, I don't know what other else to tell you. Just because you don't think that that's the way it should be, it doesn't make it so. All
Okay,
right.
how do we value the 6 years then?
Well, I'll tell you, what would happen is certainly she'd be entitled to half, at least, of his pension for 6 years. But what would have to happen is they'd have to do a quadro qualified domestic relations order, and it would go into the plan administrator, and they would calculate what it is, because obviously a lot of that pension is premarital. And general rule, anything acquired during the course of the marriage is marital property. Anything acquired before the marriage is not marital. General rule. So certainly it would be. I can't imagine that would be on a officer's or detective's pension, that 6 years or half of 6 years would be a whole lot of it. Additionally, in terms of any type of maintenance, now I suppose it might be possible that she might get maintenance. Not really probable.
She doesn't work.
Well, and you need to look at the lifestyle they enjoy during that 6 years too, because that's
Bungalow.
part of it.
They have a bungalow.
Yeah, but I mean, did they, they go on vacations every other week or whatever? I mean, they need to look at that. So that's probably it. However, when the court, and basically doing the divorce is dividing up the pie. So they're going to look at his non-marital property when they divide it up. And if they got a house, I don't know, did they get the house during the course of the marriage, and that's subject to equitable distribution?
They own the house together. They did purchase it while they were together before the marriage, but it's in both names.
Well, if it was before the marriage, I mean, and it could be that anticipation of marriage. That's okay. Even if it's not anticipation of marriage, if it's in joint tenancy, that's a different matter though. That wouldn't necessarily be handled by the divorce court if it was purchased way before they ever got married, because then you really, I don't think, could say that it was anticipation of marriage. Okay, so that's separate. But let's say that it was part of it, and let's say that they look at his personal non-marital assets. Let's say he has also, in addition to his retirement, he's got a bank account with $500,000 in it, okay, and she's got nothing. They're going to take that into consideration, and what that probably means is when they divide the marital assets, that she's probably going to get the lion's share.
Well, remember, we have an issue of dissipation too, because he has a girlfriend, like I told you, who's 28. That's got Laura from Chicago fuming because she knows some of the funds from his job were diverted to the girlfriend.
Well,
And she can prove it.
if she can prove it, then that's something. Now, understand, dissipation is using a marital asset for a non-marital purpose.
He bought her a car, Jesse. I mean, it's clear as day.
Well, but if he bought her a car and it's marital money, if he didn't buy it and he can't trace it, and it's going to be probably incumbent upon him to show this, if he if he didn't use it from non-marital money, like I said, remember, if he had a $500,000 account, that would be different. Then it wouldn't matter. But if it was for marital money, again, it's dissipation. But understand, she's not going to get the whole thing.
Right.
Let's just say it's a $20,000 car. All right, so
60, Jesse.
okay, 60.
This went public. I got to tell you why. Facebook.
Okay.
The girlfriend posted on Facebook the car and explained how she received it.
Gotta love Facebook.
28 years old. That's why.
Well, I don't think you have to be 20. You'd be surprised. But in any event, even if it's
No, she didn't know to keep it quiet.
well, but if it's a $60,000 car, the wife is not going to get $60,000 because theoretically, then $60,000 goes back into the marital estate to be distributed however the court's going to distribute it. If it's 50-50. It'd be 30 apiece, okay? Which is appropriate because again, it's a marital estate. Anything you buy during the course of marriage is marital, and that's kind of how that would shake out.
Well, he's going to argue he purchased it with non-marital funds.
Well, like we were talking about
during the original 23 years they were together before the marriage.
Right. Well, if he's got something separated and he has done that, then then that's a different story. Remember, I said, hey, if he got it out of purchased it from his non-marital monies, if he had an account, then that would be different.
Yeah. We got one more case. Let's move on to it if we could. This is Darren. He's a seasonal worker, Jesse. He was hurt by the current economic crisis. He can't find a higher full-time job, so he's still doing the seasonal deal.
Okay.
He wants to continue with his divorce case. It's ongoing right now. He's not making ends meet. He can't make his rent. He may have to move back with his folks in Hinsdale. And here's the problem. His attorney is threatening to withdraw for non-payment. He wants to know what are his options. This is Darren in Lamont.
Okay, well, I'll tell you as a judge in DuPage kind of, once said, or maybe said more than once, I mean, involuntary servitude has been, we don't have that anymore. And if, your attorney is, he's trying to make money, it's for hire, unless he does it on what they call a pro bono basis, which is he's not charging you, or unless you're approved by either Legal Aid or Prairie State Legal Services or some other not-for-profit organization that provides legal services free of charge. In that case, that's a little different.
Remember, we're in the middle of the case here, though. What are the odds that attorney is going to be able to withdraw?
Well, it depends on what stage it is and depends on what county you're in. So essentially,
Cook.
if it's
Darien.
if it's
Lombard.
if it's
Lamont.
Lamont is DuPage.
No,
Okay.
Lamont is Cook.
Lamont. Well, certain parts of it I thought were in DuPage.
Well,
Yeah, we'll see.
the case is in Cook.
Well, one or either party could be in Cook. That would be appropriate venue. But basically, the long and short is that certainly the attorney can withdraw. Now, the court doesn't have to let that person out. But let me ask this question to him: do you want an attorney who is forced to work for you for nothing to represent your interests in a divorce?
No, he probably won't. He or she probably won't put a good time in for you.
Probably not. If they're not getting paid, then that makes sense. But
Right. Well, he wants to pay. He wants to work a payment plan.
yeah,
But it's not obviously enough to satisfy a retainer, but he can put $100 or $150 per month towards his case.
well, again, that's up to the individual attorney. And as long as the case is probably not set for trial or hearing, probably the attorney is going to be able to get out, and that person would have 21 days in order to file his own appearance to represent himself, or to get an attorney, or hey, if he's in that kind of a difficult situation, certainly he could try legal aid. I don't know what the chances are, but certainly he has parents as well that might be able to assist him to be able to keep the attorney or to find someone else.
Well, they're willing to give him a roof over his head if he wants to move back in, but they don't want to pay his legal fees.
Well, and that's
they
understandable.
were not very
Right.
approving of his choice of spouses.
That's certainly their business, and they're entitled to that. So again, and that's up to the court.
What are the odds he'll have success pro se?
If his wife is represented by counsel, probably not going to be real good, but I will tell you though, the judges try to do the best they can to make things equitable. But if you're representing yourself, you're going to be held to the same standard as an attorney. That's what the law says. They don't always do that though.
All right, Jesse, thanks for joining me. These
Yes,
are
Dave.
interesting fact patterns.
Yep.
We'll see you next time on Legal Action. Take care.